Hello friends, today's topic is case law, which is relevant to the basic concept that we have studied till date. So the case law would be revolving around the definition of the basic concept or the concept that we have studied in the chapter. There are three case laws that would be covering, which are delivered by High Court or Supreme Court. So the first case law is between Honda Seal Cars India Limited versus CIT 2017 Supreme Court. So the facts of the case are Honda company and the Indian company Seal Cars India Limited entered into a joint venture for providing services in India. So in the screen you can see the SSC and Honda Motors entered into a technical collaboration agreement. So an agreement was entered in with the SSC. SSC is the joint venture company. Okay, and the joint venture company and the Honda Motors entered into a technical collaboration agreement under which a technical fee was payable by the SSC. So the SSC, which is an Indian joint venture, is supposed to pay a technical fee as per the agreement to Honda Motors outside India. Under the agreement, technical collaboration agreement, Honda Motors had to provide manufacturing facilities, know-how, technical information regarding intellectual property rights to the SSC, which the SSC was entitled to exploit only as a licensee and not as a proprietary rights. So here the word is important, in which case the SSC is utilizing the rights, is using the rights only as a licensee, and it's not owning the intellectual property rights. So the SSC in that case has treated this technical fees as a revenue in nature, because since there is no acquisition of any asset, they have termed it as revenue in nature and treated it as a deduction in the books of accounts. So this is a concept related to revenue and capital expenditure. So the SSC has termed this as a technical fee payment as a revenue in nature, and since the payment has been done, so a deduction has been claimed in the books of accounts. So SSC treated this as technical fees as revenue, while the revenue authorities contend this as a capital in nature. So the issue over here is the technical fee payable by the SSC is in the nature of revenue expenditure or a capital expenditure. So if we go step by step, so first is in the appellate tribunal or in the assessment part, first comes is CIT appeals. So CIT appeals has delivered the order saying that it should not be a revenue expenditure. Okay, and revenue authorities has contended this as a capital in nature. Tribunal view, which is after CIT appeals, tribunal says that it is a revenue in nature. It was in favor of SSC, saying that since there is no proprietary rights, the SSC is only using the license and is paying the fee, then it is a revenue in nature and hence revenue expenditure is eligible. This was tribunal views. High Court view, in a sharp contrast to tribunal view, it's like that it's a proprietary right and it should be capital in expenditure, because the joint venture which has been set up for this very purpose won't be in under existence once the project is completed. Meaning, going to the screen, the High Court however held that though the rights were in the nature of right to use, the joint venture's business was set up pursuant to the agreement and hence the expenditure was capital in nature. So the High Court has termed this as a capital in nature. In contrast to tribunal view, it has affirmed the view of CIT appeals, Supreme Court view and its decision. Supreme Court view, I will read the content in the screen. Court observed that if a limited right to use technical know-how is obtained for a limited period for improvising existing business, the expenditure is revenue in nature. However, if the technical know-how is obtained for setting up a new business, the position may be different. So, Supreme Court view is that if it's a new business, then it won't be a revenue in nature. The license fee paid won't be revenue in nature. If it's an existing business, then it may have been called as revenue in nature. In this case, a new joint venture was opened by the SSC in the name of the SSC by the Honda Motors and an Indian company. A new joint venture was opened to pay the technical fee. So in this case, a new company has been opened. So the expenditure will be termed as capital expenditure because it's a new business. So, in the given facts, the very purpose of the TCA, Technical Collaboration Agreement, was to set up the joint venture. Upon termination of agreement, the joint venture itself would come to an end. SC held that the technical fee is capital in nature, since upon termination of TCA, the joint venture itself would come to an end. So, in this, you can see how the difference between the revenue and capital nature is very important, because you have termed this as a revenue expenditure and claim deduction in the books of accounts. However, at the end, the Supreme Court had termed this by way of reasons, obviously by way of knowing the intention of the legislation, saying that it is capital in nature and hence no deduction would be allowed. However, this being a capital asset, depreciation can be claimed by the SSC on the intangible asset. At the rate of 25%, this can be claimed as a deduction by the SSC by the Indian joint venture. So it would be like if it would have been a revenue nature expenditure, 100% expenditure would have been allowed in that very year. But since it's a capital expenditure and being intangible asset, a 25% depreciation would be available to the SSC, and the expenditure, 100% expenditure, is been deferred over a period of 4 to 5 years. Second case law is between CIT versus Saurashtra Cement Limited, 2010, delivered by Supreme Court. The facts of the case I will read from the screen. The SSC cement manufacturing company entered into an agreement with a supplier for purchase of additional cement plant. One of the conditions in the agreement was that if the supplier failed to supply the machinery within the stipulated time, the SSC would be compensated at 5% of the price of the respective portion of the machinery without proof of actual loss. So in this case, if the supplier fails to supply the machinery on time, then if the hypothetical loss or notional loss of 5% will be calculated without proof of actual loss, the 5% of the price of the machinery needs to be compensated by the supplier to the SSC. So the SSC received amount from the supplier by way of liquidated damages on account of his failure to supply the machinery within the stipulated time. So these liquidated damages were paid by the supplier to the SSC. The department taxed the amount of liquidated damages of income tax, considering it as revenue in nature. Vis-a-vis, the SSC contended that it should be capital in nature and hence the receipt is not taxable. Vis-a-vis, Commissioner of Income Tax or the tax officer has contended that it is revenue in nature, hence it should be taxable. Tribunal held that the amount was a capital receipt and the High Court affirmed this view. So, Tribunal and High Court are in favor of SSC, contending it is a capital in nature receipt and hence it won't be taxable under the any income from sources. So, what is the Supreme Court decision? SC affirmed the decision of the High Court, holding that the damages were directly and intimately linked with the procurement of a capital asset. So the facts of the case, if we go back to the facts of the case, it's like this: a machinery was provided not within a stipulated time by the supplier, so it was related to a capital asset. So liquidated damages which were paid for delay in supplying the machinery are related to a capital asset. Accordingly, based on that, Supreme Court, High Court and Tribunal has stated that the damages which are paid are linked to the capital asset. Accordingly, it should be capital in nature. So it was not a receipt in the course of profit earning process. Therefore, the amount received by the SSC is not in the ordinary course of business, and hence it's a capital receipt in the hands of the SSC. Next case law is between CIT versus M. Venkateshwara Rao, 2015, Telangana and Andhra Pradesh. Facts of the case are: it's a partnership firm, so capital contribution was made by 10 partners. The SSC firm's explanation that the partners have paid various amount towards contribution of the share in the capital was not accepted, since the source of income for the partners was not explained. So the partners of the firm has contributed capital contribution, in which case the firm has stated that SSC firm, the partners have paid various amount towards contribution of the share capital. In a way, the firm is receiving certain funds, okay, and they have said, the firm is saying that they have received, the firm has received capital contribution from the partners. Vis-a-vis, the department, the tax department is not ready to accept, saying that these are cash credits and it will be liable to tax as undisclosed sources of income under section 68. The Commissioner Appeals observed that the amount credited in the names of 4 partners was valid. Fine, out of 10 partners, 4 partners was valid, and that cash credits in the accounts of 6 other partners in the books of firm were to be considered afresh by the AO. So out of 10, 4 partners was valid, but out of but remaining 6 partners, there may be a cash credit, and accordingly section 68 may be applicable, which has been, the matter has been remanded back to AO. So the AO, what he did was, for the entire 10 partners he treated this as cash credit. However, the CIT appeals treated for 6 partners same as cash credit, and the matter was remanded back to assessing officer. Issue under consideration: whether AO was justified in treating the capital contribution of partners as income of the firm by invoking the provision of section 68. Section 68 is nothing but cash credit in which the amount has been disclosed in the books of accounts. However, there is no explanation offered, or explanation offered by the SSC is not satisfactory in the eyes of the assessing officer. So in this case, in this particular case, explanation has been provided by the firm, saying that these are the capital contribution by the partners, but this explanation is AO is not satisfied with the explanation provided. Accordingly, he is treating them as cash credit. So what is the High Court view on this? High Court view is, first para states the section 68 directs that if an SSC fails to explain the nature and the source of credit entered in the books of accounts of any previous year, same will be treated as income in that particular previous year. When the firm explains, where the firm explains the partners have contributed capital, section 68 cannot be pressed into service. So High Court has held that where the firm is saying that there is a capital contribution, this cannot be challenged by assessing officer. At the most, the assessing officer can make an inquiry against the individual partners and not the firm, when the partners have also admitted their capital contribution in the firm. So there might be an assessment against the individual partners who have contributed the funds, but there cannot be assessment against the firm in such type of cases. This High Court view, High Court has made a reference to another case as well, in which High Court of Patna delivered has held this position in the case of Anupam Udyog. So in a nutshell, the amount which has been received by the firm is indeed was held to be a capital contribution based on explanation of the firm, and it won't be treated as cash credit in the hands of the firm. Vis-a-vis, High Court has held that it can be termed or further inquired in the hands of the individual partner, whether cash credit should be considered in the hands of the individual partners. So to sum up, we have read 3 case laws, in which first and second is regarding revenue and capital expenditure, and how important is classification between revenue expenditure and capital expenditure, and revenue income or capital income. And the last part was regarding the undisclosed income, regarding the cash credit, whether the funds received by the firm can be held to be a cash credit or not, and there is a case law view of High Court on the same. Thank you.